And just like that, we're off. This isn't just another landlord-tenant spat. This case sits right at the crossroads of commercial law, residential protections, and self-representation roulette. Buckle up, because when parties walk into this moment right here,
Motions one. Okay. Have you, let's start with this motion again. What you're saying. Are you guys going to represent yourselves? Yes, I. Alright. You know how to respond to a motion. Let's see. Let's say yes or no. Alright. I don't know.
That's a no.
I haven't. Did you file a response? Pardon? Did you file a response to the motion for assembly?
Your Honor, we received that response.
Pardon?
We received it.
Yeah. Okay, now I see. Yeah. Okay, what motion do we want to start?
Whatever you'd like, Your Honor.
I really don't have a preference. It might be, I guess, if I take them in order how they were filed, but I mean, whatever. What would yours?
I mean, selfishly, I'd like to discuss my motion first. I think it takes away a lot of their arguments.
And let's go there.
Oh, fine.
I can go. What?
Fine.
Okay. Go ahead.
Your Honor, I mean, landlord's motion for summary disposition, I believe briefing, like the lease language itself, is clear. The lease express provides that tenants must pay monthly base rent $500 without any deduction or set off whatsoever. As this court acknowledged at the November 7th hearing, which attached the transcript as a the court correctly stated like lease language is not conditional. Tenants in their response completely ignore that lease language regarding the rent payments. Your Honor, going to the reply, or the response, their sole defense is that this is a residential lease. I believe the argument is meritless. I don't like throwing this word around, but I believe it's also frivolous. Tenants admit in their filing for emphasize that they're operating a commercial horse farm on the property will award equestrian. Tenants don't reside in the property, and it's a business collecting money from boarders boarding their horses at the farm. I'm going to read paragraph 2 from the circuit court complaint. With award leases the property to conduct your business, will award equestrian LLC. Allowed on the property by the lease, Scioto Township regulations of agricultural/farming use. Erica's business is a equine boarding and training facility, and then it continues. Your Honor, again at the November 7th hearing, you acknowledged commercial lease offices. The 7-year lease term that ends April 30th, 2028. Your Honor, you've read more leases than I have, but I have never seen a 7-year residential lease. Personally, paragraphs 4 and 8 also support that it's a commercial lease. I'd also like to highlight in the circuit court, tenants individually are bringing a business interruption.
Can I just stop you for a moment?
Yeah.
Are you really arguing that this is not a commercial lease? Yes, I'll be arguing that it's a residential lease. Tenant.
huge red flag. When a judge asks, "Do you know how to respond to a motion?" That's not casual small talk. That's the court quietly checking whether this is about to turn into a procedural disaster. Spoiler alert, it often does.
Landlord the entire time acted in harmony with us in residential lease premises. Okay, but you guys aren't residing there. Right now, no. So, what human being is residing there on those premises that couldn't make this a residential lease? Property is what we need. Property includes apartments with furnace. Right, this is the obligation. The homeowners see the lease from Plano in Obviously, I'm not. Let me ask you this. Do you know what a residential lease means? The residential lease, I believe, bonus of repairs and different applications and things. Well, customarily, yes. But maybe you need to understand that the residential lease can, even if, let's see, if it's just on it's quite frankly, and many apartments, the residential lease, even if it were a residential lease for a period longer than a year, the party can change the requirement of who has to repay. So basically what that would mean is that even if it's a residential lease for a longer period than a year, the term that you're complaining about wouldn't matter. The term is where the term is. That term could be in a residential lease, provided the residential lease is for longer than a year. Sure. Put another way, right? The obligation to repair can be changed if the lease is longer than a year. You have to be notified of the obligation of repair if the lease is changed. Pardon? So the second time notified, the obligation of repair has changed. It wouldn't be changed. It's just the section 6 does state that the landlord should make all necessary payments or payments differently and accommodating heating, definition, electricity. That's fine. The problem is you can't withhold. I mean, I'll let you make your argument. I just don't think it's going to get you anywhere. Like, go ahead, Joe.
I'm sorry, do you want me to continue?
Yeah, go ahead.
The party also signed in addition to the lease, a guarantee, a separate guarantee agreement, with also evidences that this case is commercial in nature. Tenants make a good point. The lease also went in our favor that the lease does not contain normal boilerplate statutorily required notices to a residential tenant. Again, it's evidence that it's not residential. Your Honor, even if they're trying to transform a commercial lease into a residential lease, they are, impermissibly subletting or allowing someone to live on the property. That is grounds for default and termination of the lease. So if that's what they're arguing, that works in our favor because
in legal terms, calling an argument frivolous isn't just trash talk, it's a warning shot. It means the court could see this defense as legally baseless, and that opens the door to sanctions. Translation? You're not just losing, you might have to pay for losing.
That is a separate ground for termination. Your Honor, the case law is clear that tenants may not withhold rent for repairs in a commercial context. I've cited these cases many times to you. They're cited in the brief and also attached. The unpublished is also attached to the brief. I would continue that tenants are responsible for the actions of their former counsel in withholding rent. I should highlight, just for the record, in any subsequent, proceedings, Ms. Hope did file an affidavit attached to the response for that copy. Appears to have just copied the case in large portions of Mr. Ward's affidavit. It talks about how she signed the lease and how she works at Mr. Ward's employer. So I would just like to highlight that for the court. That was in response to our amnesty.
Thank you. Before I have you, who represents you guys in circuit court? Okay, this time. you realize that in these two proceedings, whether the representation is made by you or whether it's being made by your attorney, that you can't make inconsistent representations. You realize you can't do that. You're not representing this? No, that is not here yet. But maybe I shouldn't use the word representation in this. You can't say one thing in one case and then another thing around. So I'm to understand what you guys
Well, you can, but it'll bite you in the ass.
may not have said it yourselves, but have said it to an attorney. As I'm to understand and what I see, your attorney, Mr. Toad, has made the representation in a circuit court matter that this is a commercial property. Okay. Okay. I don't know. Now, pardon? I don't know. But you, folks, this is where the problem comes in, was he not being represented by counsel. Because if you're going to, and I'm going to give you one break, or as many breaks as I think are appropriate, but if you persist in it, there's going.
This is the turning point. Residential leases protect people who live there. No residents, no protection. The judge isn't confused, he's testing credibility. And every pause, every vague answer, that's tension stacking up. Okay, this is
to be problems. Because if the representation has been made that it's commercial property there, and then you're left to argue before me that this is a residential lease, that's going to be a problem.
Problem like sanctions on top of losing.
A sanctionable. Because
Oh, what do you know? I hadn't seen this yet, but the implication was rather clear.
as I almost have to believe that if you're arguing that, you're arguing that in that case. I'll put it another way. If you two
I like honking for bonking. I think that's a lot better.
were attorneys and you came and you know in another action that you're making an inconsistent argument. And I'm not saying inconsistent arguments can't happen, but if in one proceeding you're characterizing something one way, and then in another proceeding characterizing it a different way. If there were a single counsel doing that, I would have very little tolerance for that, and I would be sanctioned. Meaning, every time that representation is made to me, you're going to either have to pay the court, or you may have to pay attorney fees to the other side. I understand. Hold on a second. Do you realize that's where you guys may be headed? Yes, interesting. You got your notes that not realize that, yes. Normally, I can go to the talk, so would say, verify. She's just going to call from the INC time. So, I 100% sure. Folks. She's out of the yes. You're now before me arguing this case. I won't be sanctioning her. I will be sanctioning you. Because when it comes out of your mouth, you're stuck. Your advice is whatnot. You don't really have advice. Look, folks. In this case, Your Honor, my other course was to comment on the residential assets of these. Yeah, so that is what I'm not going to say. So here's what here's where I have to stop, because there's been documents filed in your.
It's no longer about rent or repairs. This is about truthfulness. Courts tolerate bad arguments. They do not tolerate inconsistent facts across different courts. At this point, the judge isn't hinting. He's flashing neon warning signs that sanctions are on the table.
Yeah, in a different court. Albeit you're represented by an attorney, they're really your statements, right? Saying something different than the two of you right now are going to say. I anticipate I'm going to say it, okay? I'm doing my. I don't want to yell at you guys. I don't want to sanction you. I really don't. I can tell you right now that if you had the same attorney was doing that in two different courts, and I was aware of that, I rarely lose my mind and go off. Well, probably do one issue. But anyway, I would be going crazy. And I would be holding their feet to the fire and making them explain in detail to me how they can have these inconsistent positions. Because here becomes the problem, folks. If you're making that representation, you're probably doing one of the most serious things that a person should not do to a court. And that is that you're misrepresenting facts to me, or you're just out and out lying. I did not, Your Honor. I did not realize that she represented the other court in the commercial matter. I did first at her, so again, what show before judging. I didn't say, but I did not. I read those statements. I'm not an attorney. I did not see that, that she had done that. Of course, I would not represent T0 to the losses. I'm not an attorney. Yeah, but do you understand the predicament you're in right now? Oh, I do. Because if you start that argument, and if you guys want to represent yourself, I'm going to hold you. I'm going to hold you as accountable as I would. Is it possible for us? No, because honestly, we don't have an attorney. You get an attorney at this point or that or lost. You know, always get an attorney. Sometimes you can walk out in the hallway, throw a stone, and you'll hit one. You can always have an attorney. But I've given. Well, how many times I've adjourned it? So, well, I adjourned it a number of times. Tried to give caution about your representation. And we gave you an opportunity for you guys to make your own decision about how you want to proceed. Well, let me ask you this, just get me aside. Why didn't you have it? Yeah. I believe I said the whole time. I didn't. I couldn't see a pathway we could make it wrong. On the case we're talking about, we wanted to do like gas leak and try to protect people against using possibly like rocks. You have people living in a place, gas leak and a shower cap them. Or it's just 5 years before. So
I'll translate for you. We couldn't find any attorneys who want to take the unethical and insane positions that we want to take.
if you get that process next day, I we got before we had to typically at least the same process. I could not see the other word.
When a judge starts referencing Better Call Saul, you know things have gone off the rails. And here's the brutal irony. By trying to claim residential protections, the tenants may have accidentally admitted to unauthorized subletting, which in a commercial lease can be an instant default. Oof.
You try to get those things correct first on the gas leak was wrong. We got the 401 to my own southern repairs, pumps. Yeah, well, that's why it is.
Yeah. But if you're renting that property,
Not rented anyway.
somebody's just there.
Yeah. My daughter's sleeping right there, my wife's sleeping right there. Just warning to stay there.
They had the only one that would do it.
But the hot water change just for 5 good observation around. I felt yes. Yeah, that's why you think so dangerous. I don't know, I didn't get anything wrong.
This reminds me of the bit from Better Call Saul. You don't need a criminal attorney. You need a criminal attorney.
Here's what you need to understand. This is where it gets kind of weird. Just based on the scenario you've given, whether you're charging them or not, you would effectively be somewhat. Just friends with people living in it. Stories do have place. They hear you, but you cannot. You can't do both. You can't analogize this to a residential circumstance because you're creating a residential thing that that's how you do it sometimes. Or change something. And you're gonna have a problem. Folks, you're gonna have a problem. You know, you truly believe that this is residential, then first of all, I think you're going to have a problem and you're going to subject yourself to sanctions. But if you in your heart and your analysis believe that this is residential premises, then that means somebody on your behalf in circuit court has not told the circuit court the truth. I see the problem.
Here's my thing with Judge Simpson. I agree with his analysis of this 100%, and I think he's a sharp guy. But a much easier approach is to say, okay, present your motion. Denied. Next.
And then you're going to be subject to sanction. Folks, when you file these documents, you realize that you're representing that the information contained in there is true. I do realize that. And you realize that if I find that it's not true, what I can do. I don't think you understand. No, I don't know that. I'm trying to do the right way. You've risen. What do you want to say?
Right. So they already rang the bell by filing this response with both of their affidavits, with Ms. Tope's affidavits. I'm not recalling if one of the other forms also is coherent to whether it's a residential lease.
You can't ring this guy's bell.
But I'm saying they've already rang the bell on sanctions.
There you go.
The sole defense to our MSD is that it's a residential lease. or is the circuit court that also bring the business for appearance complaint seeking lost profit damages for their business. So that's where we're at.
Are you saying anything else? No, Your Honors. The report's calling about my attorney. Pardon? In the other case, I'll be calling my attorney. I'm not saying anything to do with my self-sanction. I just
Oh, you already have.
I that's a problem.
Too late, big dummy. You said it, and you filed an affidavit with the court. With your stupid sanctionable stuff all over it.
Oops.